Good morning, members. This is the 5th Bills Committee meeting on the Marriage Amendment Bill 2014. We can start because we have formed a quorum. Let's invite the government officials to come in. I will introduce the government officials in attendance later. Since the last meeting, the Secretariat has received from the Bar Association and another submission from another organization. So these submissions have been distributed to members. The government, in relation to the meeting on the 1st April, made a response to members' concerns or requests. And these points have been sent to members as well. So you can see the paper being tabled. Later on, I will invite the secretary to make a briefing on the paper. Yesterday, we received a paper from Mr. Chan Chi-chun. It's now tabled for members' reference. I will deal with it later on. For CB bracket 115901314 bracket 01. So let's see whether the Secretary would like to make a response. Thank you, Chairman. I would like to make a few remarks first, and then my colleague, Ms. Ju, will take you through the paper that we have presented. Chairman, the purpose of this bill is very clear. In the W1 case, the Court of Final Appeal made a ruling, and the number of provisions in this bill is small. A number of meetings have been held. Public hearing has also been held. And in the meetings, we've heard members' views and also views of the public. This is quite a broad topic. In fact, we have received views on many other aspects, not only about provisions in the bill. So, in other words, these views are not directly related to the bill. In the W case ruling, the court stated that the government has to look into issues arising or associated with this case. And the government attaches a lot of importance to this. A high-level cross-department committee has been set up, led by the Secretary for Justice. And members of the committee, had also given presentation to this Bills Committee. In mid-July, the CFA ruling would take effect. So I would invite this committee to scrutinize the bill as soon as possible so that there will be enough time to table the bill to LegCo for third reading. Deputy Secretary, Chairman, members, in the W case, the CFA made a ruling, and before the commencement date, if this bill is not endorsed, if scrutiny of this bill is not completed yet, then what will be the effect? Now, we have set out our understanding in the paper already. On the 16th July last year, CFA made this order. And in relation to Section 40 of the Marriage Ordinance, the meaning of the terms is such that people who are converted from male to female should also be included or accepted by the provision, and the appellant should be regarded as female. And under these two provisions, they have the right to get married. And this order will be suspended for 12 months so that the administration can consider relevant legislative amendments. Now, in the judgment, it is stated that even if this amendment cannot be passed during the suspension period, the court said that the interpretations and explanations should also take effect. So people in similar situation as W should be entitled to get married as well. So all along, CFA judgment will become part of case law. So according to common law, during the suspension period, at the end of the suspension period, this ruling will take effect immediately and become part of our law. And when it becomes part of the law, then the administration has the responsibility to do its work according to this court order. So in other words, after the 16th of July, no matter whether the bill is passed or not, if there are people similar to W asking for marriage, then the administration will have the responsibility to register for that person. The only objective of this marriage amendment bill is to show that we respect and would implement CFA ruling. So with statutes, we hope that we are able to adequately reflect the two genders in the law, so that in the future, people similar to W will have their rights being protected clearly by the statute. So this is an objective of our bill. We support the rule of law principle. Of course, there are other associated amendments, and these have to be amended as well. Thank you. Just now, the Secretary and the Deputy Secretary presented their view and also their attitude. They hope that by the 16th of July, we're able to complete scrutiny of the bill. Of course, this is the recommendation of the administration. We have to be careful with our work. We can assess ourselves whether or not we are able to do it in time. My view is that we can make a decision later, depending on the progress of our scrutiny. Of course, if possible, if we can do it before 16th July, since there is this CFA ruling, we should also consider showing respect to the court. So this is the attitude that I would like to adopt, depending on what members' views are. In the process, now there are some representative organizations which have made submissions. They have expressed doubts and reservations. And so can the administration give a very clear view or response? For example, some religious groups have expressed their views. If this bill is passed, they have to grant exemption about marriage. So can you give a response? I hope you can provide a paper. The Bar Association, the Law Society, the EOC, and some other organizations are professional bodies. They have presented their views to us. So I think, of course, it's up to members to decide whether we want to take on board their views. Okay. On the points just discussed, I will invite members to express views. Ronnie Tong and Chen Shiqing have indicated their interest to speak. Okay, 5 minutes each. Mr. Ronnie Tong. Chairman, to a certain extent, I agree with you, Chairman. Of course, I understand the administration's worries or concerns about our scrutiny work. When we evaluate this bill, we don't only consider the CFA ruling. CFA made a ruling based on all the facts in front of the court, and they made a decision as to whether Ms. W is male or female in that case. But we have to look at the definition of male and female. And the court did not insist on what attitude LegCo should adopt in defining male and female, so they have shown respect to the independence of LegCo. So, yes, this 12-month suspension period will expire soon. I don't think the administration should say that we should scrutinize this bill as soon as possible because of the time constraints. They should look at whether or not difficulties that we have encountered in our scrutiny work can be solved. The definition is very controversial. It's difficult to convince people to understand why this threshold is so high. And it is not appropriate for all the transsexual people. So I think this point has to be handled by the SARG. Otherwise, the SARG cannot assume that LegCo will definitely endorse the bill presented, or that LegCo will accept the definition set out by the SARG. So the SARG should work harder. You should not just say that time is almost up. We have to complete our scrutiny work as soon as possible. I think that attitude should be improved. Any response, Secretary? Thank you, Mr. Tong, for your reminder. As I said in my opening remarks, the administration attaches a lot of importance to the issue. However, the CFA made the ruling on whether or not a transsexual person should be regarded as a male or female. And in the ruling, CFA made a lot of points. They have considered all the papers and also testimonies from experts presented by the government. And Ms. W has presented a lot of justifications. These have been considered by the court. There is another relevant body which made submission to the court. The court, after careful consideration, had explained with a lot of details the complexity of this case. And Justice Chen said that this issue, it's not easy to come to a consensus in the Hong Kong society. Chairman, I guess we have all read the judgment. The Secretary doesn't need to repeat the issue. What I want to say is that person has gone through all the procedures in that case, and so CFA had made a judgment. It doesn't mean that when we do legislative work, the threshold can be relaxed or made more reasonable. Even if this bill is not passed, in the future, let's say there is another person, but he or that person is not up to that very high threshold as in the W case. Now, CFA may still apply the same yardstick to deal with a lower threshold case of transsexual person. So you cannot assume that this doesn't exist. So our consideration will be different from the CFA's consideration. I hope the Secretary can understand. Yes, I understand. Actually, I was about to make this point just now, sorry. Just because of this issue, in the public hearing, many deputations spoke. There are actually not fewer than 100 deputations who gave their views. They have different views. Today, if we want to build a consensus in society, it is not easy. And because of this, the government needs to set up a high-level, cross-department, cross-bureau working group. I would like to give an example. On this point, in Europe, well, more than 1-2 decades were spent to consider many cases. They had a lot of arguments, and only after that did we see some change. And in the UK, many cases showed very clearly that there's the need for a long time to build consensus. The British government spent 6 years to deal with this issue. Today, if we say now how we should define a person as male or female, under what circumstances, well, if we are to say that we want to do a complete study, we want to do consultation and discussion to consolidate all the views, I think we still need very long time.
So the government's decision is divided into 2 parts. First is to take effect the CFA ruling. That is our main objective. We're not going to do one first and the other later. Our departmental working group is already looking into the matter. We want to look into this matter carefully. Well, you might ask if we are able to complete this within the remaining time. Are we really able to do it? The public has different views and positions on this. How are we to reach consensus? There's still a lot of discussion, and we are only in the very preliminary stage. Under this circumstance, I believe that we should first try to take effect the CFA ruling first. Well, thank you. Yes, I think we are clear on the Secretary's position. Well, from the first meeting till now, I think we have maintained different views, but we understand your position. Mr. Chen Chi-chuan, thank you. Well, the Secretary knows the difficulty. The CFA ruling the order came down in May of last year, and the first reading was only on March 19th this year. So you're forcing the LegCo to finish the scrutinizing the bill within 3 months. Well, why didn't you deal with this matter immediately after the order came down last year? So who's not respecting the CFA? It's the SARG. I think that in handling with the bill on the marriage bill, you can say that the government is trying to evade the issue and trying to shirk its responsibility. Anyone who has attended the public consultation has shown that they are not in favor of the amendment bill. The EOC said that if you don't list out the SRS in the legislature, then it shouldn't take effect. And even the Bar Association has submitted 2 letters, but the government has not listened to any of the views. The administration is refusing to change any of the wording, and the government is not going to delay it. Well, I'm not sure whether there are enough votes. Well, I'm going to bring this to LegCo by July 15th. So this is the imbalance of legislature and justice, because the administration has brought up rubbish to LegCo and forcing us to make our decision within 3 months. Well, Secretary, we want to also to push this forward as soon as possible, but this is not the case in reality. We have asked very simple questions, but there has not been one that you are able to provide us with a clear answer. Well, it's very clear that these are just legal questions, A, B, C, D, but you are shirking your responsibilities because you didn't know how to respond. So you try to respond it all together instead of one by one. I'm going to pick it out one by one and ask you once again. For the Law Society, it said that the suggestion might be in breach of Basic Law Article 37 and affect some of the rights and many of the covenants, both of the United Nations and of the European Union. Secretary, can you either in written or verbal form explain to us why you think that your amendment has not been in violation of these covenants? Well, we have the final decision on when we can bring this to the LegCo Council. So I just want to make this clear before I ask the Secretary to respond. Thank you, Chair. Mr. Chen Chi-yun's view, I'm not in agreement by his saying that the government is shirking its responsibilities. The order was handed down in May of last year. How could you really do anything before the order was handed down? In December of last year, Mr. Chen Chi-yun also suggested a debate on this. Actually, this case is very complicated and complex, and it's taken a few years for the case to be completed. I said earlier, and I would repeat myself once again, take a look at the overseas cases and precedents. And people's mindset and attitude cannot be changed within a day. And all the different views fully support my view. The administration has decided to use a two-pronged approach. We are going to through legislature realize the order handed down by the CFA. This is our constitutional responsibility, and at the same time, the CFA has clearly stated that this is a very complicated matter, and you need to look at the level and degree of the case. The CFA, the different courts have all handed down their judgments, and if you look at all the judgments, you would see that they all have different viewpoints, even though there are 9 different judges. So we would take the two-pronged approach. We have suggested an amendment bill, and we were going to use all the same wording for the bill to be passed in the legislature. And secondly, we have also asked formed a IWG to commence work to conduct a comprehensive review of the legal issues. And I believe myself that we should at least pass legislation in accordance with the order handed down by the CFA. If you say that by doing that we are going to violate human rights or people's rights, pardon me, but I'm not able to understand why we would be in violation if we are just taking effect the order handed down by the court. Thank you. Chairman, yes, we are dealing with a very controversial issue, but it also has to do with basic human rights. The court has made a judgment and handed down a order that these transsexuals have the right to marry, and we should amend our law. But the court didn't say that people who have completed the full SRS should be the only ones to have the right to marry. The court has asked us to look at the other presidents overseas and have also asked us to look at the Gender Recognition Action 204 in UK. The administration is now using a very conservative way to try to evade the issue. If the administration doesn't agree with Mr. Chan Chi-chen by saying that they are shirking its responsibilities, at least they are trying to evade from controversial issues. We're talking about transsexuals here, their right to marriage. Yes, the W case was on a woman who has completed the full SRS. The government is just bringing up a technical amendment in its most narrow way definition and try to deal with the issue. But this problem would still be here, and the government has the responsibility to pass legislation to define this marriage right under law. And if we only follow the most conservative way as stated by the government, then it's not enough. Well, if you remember from our hearing, there's both support and objection to many of these decisions. And I think that if the government is responsible, well, you have already brought up the amendment in accordance with the court, but now I think that you should take this back because both sides do not agree to your point. So how can you deal with the order given by the CFA? Well, in my understanding, even if you don't pass the legislature by July 16th, the order of the CFA would come into effect in any event. So regardless of whether or not there's a legislation in place, it will still come into effect. I think the government needs to bring up legislation, but it must go through more detailed consultation and consideration. And after consultation, you would bring this up again with using another yardstick. So that means that you're saying that since in any event it's going to come into place, you want to disregard this. No, I'm saying that yes, it's already been brought up to LegCo. And after preliminary discussion, we have found that it's difficult to come to a consensus at this stage. And I think that it's very difficult for us to pass the legislation by mid-July. So in any case, if it's going to be that difficult, we should we should think of a more detailed consideration before we do anything. Because I know that there is a sunset clause, but we're telling the public that we could do something within a year or 2 years to set another benchmark so that in 2 years we'll be able to reach a consensus. This could also be a kind of this could be a new way, but the administration has refused to do that. So I think that the administration should either take this back or set a sunset clause. Secretary, please address Mr. Fernando Cheung's question. Well, the administration is not trying to evade from the issue. If we are evading the problem, then we wouldn't need the Secretary for Justice to set up an IWC to look into this matter. If we're just looking at this from a technical view, we could just execute and I'll just make an amendment. We're not trying, and that would be all right. I want to once again say I'm sorry. We did not try to evade the issue, but it's a very complicated matter. As Mr. Fernando Cheung said, we need to consider it. Well, see, if you look at the different courts, only the CFA supported W in amongst 9 judges. There are some judges that supported the government, and yeah, of course there were some that did not support government. So that's very complicated because there were different views in the different courts. Well, if we are not taking responsibility and we are just stopping here, then yes, I agree, and I agree with Dr. Fernando Cheung's criticism. But that's not the case. It's very difficult for us to reach a consensus for this complicated matter within 12 months. Take a look at other countries. Other countries also need a very long period of time before they could set legislation. And under these circumstances, the government needs to first realize its responsibility to make sure that the order of the CFA comes into effect first. For other issues, we need to do more research and consider the issue even further. This we are in agreement. Thank you, Mr. Liu Cheng-gong. Chairman, regarding the Marriage Amendment Bill, my understanding is that this is only a temporary amendment. The objective being to ensure that the order would come into effect and to make sure that W could get married. I support or agree that there should be legislation made in future regarding transsexuals. Many colleagues have said that the definition of women and of male and female because of transsexuals is quite controversial. Well, I think that it's very unrealistic to think that we will be able to conduct public consultation and put this into legislation within 12 months. Well, even if we're to do something like the UK's Gender Recognition Action 2004, we still need to first reach a public consensus. Right now, we cannot reach a consensus because we have not yet held any public consultations. And this is what the IWC is doing right now. IWG is doing right now. So, in legislation right now, if we are to make a full SRS as a requirement and to put this under temporary legislature, this I could agree with. As for W's threshold, where should we draw the line? At this moment, I don't think we should just draw a line. Yes, people might bring this to court again in the future. But what does the public think of it? We don't know yet. And that is the reason we need to first conduct consultation. I think right now we should just try to set temporary legislature so that the W case could be completed under the order. But I think we still need a detailed consideration before we set a full legislation. Well, I think that this is a very clear viewpoint and a simple way of putting it. This is a very complex matter, and therefore we do need to do more research and to conduct more analysis and consultation before we could reach a consensus. Otherwise, if we're just pushing forward a legislation to just ensure that the marriage ordinance could come into effect, people might think that we are just pushing it. Well, some colleagues have said that, we are not taking a responsibility. Actually, we're not. We have thought through this very clearly, and we believe that this is the best way forward. Thank you.
Ms. Wong pick one, and then Ms. Leung Mei Fan. Thank you, Chairman. Now, as we all know, as stated in the government's paper, if we cannot pass this bill before the 16th of July, there will be some impacts. In fact, there is not much impact because according to that ruling, transsexuals can have the right to get married. We just want to tidy things up in the law. Now, this bill is presented in front of us. We won't disregard it. We won't just stop our work. A bills committee has been set up, and the chairman is leading us in our work. I suggest that we should continue to scrutinize this bill. Is it possible for us to finish our work before the 16th of July? Now it seems that there is not much time left. If we're able to scrutinize this bill, if we can make it before the 16th of July, then okay, that's fine. But reading all the provisions, there's still a lot to discuss. If you look at 40A, it sets out very clearly the gender status and the full sex reassignment surgery. So there are a lot of things to argue about. Last time, the government invited Dr. Yun to give views. I think you have sought his views some time ago. What do we mean by full sex reassignment surgery? It seems that there is not much room as stated in your paper. And when the transsexuals go through the SRS, is it really possible to achieve that threshold? Because some sex organs have to be removed and some sex organs may have to be added. And last time, the doctor, being a surgeon, gave explanations. It's easier to cut off or remove the breasts. It's easier to operate on the upper part of the body. But then you won't regard removal of breasts as part of SRS. Why? is this really uncontroversial, a very professional description? What should be included, what should not be included under SRS? And then the inclusions and exclusions may lead to different legal effects. If you say you have to complete 1 to 7 before you are regarded as transsexuals, then perhaps in Hong Kong there are not many transsexuals. Then it may be a waste of time to work on this bill. So we need more time to listen to the transsexuals or to those people who have difficulty in identifying their gender. We should understand their difficulties. Is it because they cannot go through certain operations, or some operations are not mature? And for example, the addition of penis, this is regarded as very difficult by experts. And even if such an organ can be added, it won't be functional. So it may be, it may entail a lot of cost, but if that is not done, then that person cannot be regarded as transsexual. So I support Mr. Chen Chi-yun's suggestion. Perhaps our Bills Committee can listen to more experts' views, including the psychiatrist's views or psychologists' views. And we can also look at what are included and what are not included in SRS in other countries, and we can see whether Hong Kong can meet those standards. Secretary, Chairman, I may need a bit more time, so I hope, Chairman, you will allow. I agree with Ms. Wong that we should proceed with discussion of the actual provisions as soon as possible. What we want to do is to make sure that the law is as clear as possible. This is a unique characteristic of statutes. Even though I am not a legal expert, I believe that should be the case. In the WK's trial or hearing in CFA, there's Dr. Yun from Hospital Authority. Dr. Yun is the most experienced doctor in handling this kind of operations in Hong Kong. He said that he had performed over 100 operations, and in Hong Kong, in the government, he is the leader of this area. Apart from Dr. Yun, during the trial, Hospital Authority, Dr. Ho of the Psychiatry Department gave views. Para 12 of the CFA ruling quoted Dr. Ho's views. So in other words, CFA has taken into consideration various evidence and information before handing down the judgment. Dr. Yun, at the last Bills Committee meeting, said very clearly that the operations he has performed are effective therapies or treatments. The International Anxiety Association adopted also the same standard in handling people with difficulties in recognizing their gender. Now, in Hong Kong, we have not set our own standards. However, Dr. Yun and the whole Hospital Authority team adopt some standards and codes, and these are in line with international standards. So there is no clear departure from these international standards. Ms. Wong, you talked about breasts. Perhaps I will invite our Deputy Secretary to explain. Please be brief. Chairman, according to Hospital Authority experts' views, they are in line with international codes and standards. Now, for the transsexuals, For male, of course, they have their very clear sex characteristics. And for male, we're talking about testes and penis. And for female, breast and vagina. Now, these are regarded as basic standards. Now, breasts are regarded as secondary sexual characteristics, medically speaking. Whether they are of big size, whether they exist, well, this is not a basic consideration in defining gender. So all along, the breasts are not included in the operation. Okay, Ms. Leung Mei Fen and Mr. Paul Tse. We are talking about the marriage system. Today we are discussing the Marriage Amendment Bill. I don't think it is of temporary nature. Some members may think that this is temporary in nature, but this is not the case. There is no consensus that after this amendment it will be amended again. That's the first point. Para 2 of the ruling states clearly that the ruling is not related to homosexual marriage. So it's a remedial interpretation. So there is still one husband and one woman, one male and one female. So for those people who have gone through the SRS will be regarded as belonging to the new gender. So it's still one man, one male, one female, not half male, half female. So in other countries, there are some other cases. And when those transsexuals who are not totally transformed go to the male or female toilets, there are troubles. So part of the ruling is binding. Part of the ruling asks us to discuss. Even though I do not agree totally with either part. The court hopes that we will do our work on certain parts. I won't object to that part, but for the part that is not binding, I have a lot of views. I think that the court should respect LegCo and our society. We are a Chinese society, and in the public hearing, there are a lot of disagreements. I hope that there will be time allowed for LegCo to debate. So whether or not this marriage amendment bill is temporary in nature, I don't think so, definitely. I think we have to be clear what we are doing now. I don't think we should believe that this is temporary in nature. We should express our views very clearly. Dr. Yun has replied to me a few questions. Now, it's not a kind of torture, or it's not a very harsh sentence. And if you look at ICCPR in terms of ethics, in different countries and jurisdictions, they have their own rights. Different American states have different laws. So the court cannot make this binding. The court cannot force LegCo to follow. It's okay to discuss. And under Mr. Yun, he leads a team. I think we have to invite Paul Diamond from the UK. He is involved in a lot of litigations. After the Gender Recognition Act is enacted, there have been a lot of court cases, and the cases are actually very, very odd from time to time. So it is tragic to follow the UK. We always think that we have to follow the UK, but I disagree. It's not only about copying from a jurisdiction. In the US, there are some states where they have almost lost all their money in litigations. So we should not look at this issue in a very simple-minded way. We understand the administration's difficulties. I think the administration should only work on the binding part. The court should respect LegCo. We should be given the chance to debate. The same goes with Justice Yun. He should consider overseas court cases. So members should not misunderstand that this is temporary in nature. We are really here to amend the marriage bill or marriage ordinance. Any response, Secretary? Thank you, Chairman. Thank you, Ms. Leung, for pointing this out very clearly. Our discussion today should focus on marriage under Hong Kong law, that is, marriage between one male and female. This is very clear in court. Our marriage is marriage between one male and female. And in the W case, the court stated explicitly that they are not handling homosexual marriage. So I have to thank Ms. Leung for pointing this out very clearly. I'm sure, well, since this is stated in para 2, I think the judges want to make this point very clearly. Justice Yun leads the IWG. Why do we need an IWG in the government? Why can't the Security Bureau take the lead, or why can't other bureau take the lead in the work? In our discussion just now, we all agree that this issue is very complicated. There are mixed views. And the court has not really made a ruling. Why? For the same reason. I will surely relay Ms. Leung's points to Justice Yun. No matter what the result of this scrutiny work is, the court ruling will take effect on the commencement date. This is the Hong Kong law. We do have our constitutional responsibility. If we use other ways, if we use other adjectives to express or deal with the court's ruling, I don't think it is appropriate. So in fact, we have gone through very careful consideration. We want to adopt this two-pronged approach. First, this issue is very clear and exact, and we need a consensus today. We cannot make any decision, or we cannot have any position. Mr. Paul Tse and then Tan Ka-pik. Chairman, I think this W case has highlighted the conflicts between the judiciary and the legislature. Apart from the case about right of abode, from 7 years to 1 year. Now, I think we have to sort out not only the situation about Ms. W, but all other people who are affected. But then this idea is not realistic. Justice Chan Xiu-hong made his points. I agree. There is not a consensus yet in Hong Kong, and the ruling will lead to a lot of problems. In the UK, they took 6 years, from 1999 to 2005, to complete the work. As Ms. Leung Mei-Fun said, even the work is completed, there are more troubles than benefits. Now, the CFA gave 12 months for the administration to complete the work. This shows that many judges are working on an ivory tower, ivory tower. So I think we are talking about rational decision. It's not true that some judges are really more superior. It's just that they have worked for the cause for a longer time. Now LegCo is forced to work based on this unrealistic position of CFA. Without the 12-month period is easier. If it takes immediate effect, then I think we can just follow it, but it's not possible to complete work within 12 months. The Bureau wants to respect CFA's ruling and rule of law spirit. I understand this, but I think perhaps you have to go according to CFA's request. You may have to apply to extend the suspension period. Because the suspension doesn't only apply to W case, also to other cases. If you respect the court, then just show total respect. Otherwise, please just disregard the court, because theoretically speaking, the W case has been settled. Given so many disputes, no matter whether we consider Leung Mei-fen or Chen Chi-chun's view, I think you are in a very difficult position. I think you have to wait till there is a consensus. I don't know whether that will happen, but at least more work should be done about recognition of gender. Perhaps you can try to get more time from CFA, or you can be a bit more passive. In some cases, the prosecutor thought that there should not be a ruling, but perhaps it's safer to ask the judge to come to a decision. So they refrain from the approach of offering no evidence. Now you are in a very difficult position. You just want to pass the ball to LegCo, and you can say that you have tried your best. Then that's another position. Then perhaps we can go according to our own attitude. We can decide whether we want to support the government. So 2 options for you, Secretary. You can apply to the court to extend the suspension period. Otherwise, just give the whole thing to us for us to work on it.
Secretary, I can only say that at this stage we would do our best to state the views of the government to the public and to LegCo, and to fight for completing 3rd reading by July 16th. We think that this is in accordance with the spirit of the law and that it is the most fair and transparent way. Thank you. Any follow-up, Mr. Tse? Well, I understand your line, Secretary. So are you saying that you're not going to take this back, rescind it, or what? Well, I think I've repeated many times that we need to use our best effort to pass this legislation, because that would realize the ruling of the court. But then, well, you wouldn't be able to do everything, because you're supposed to do everything within 12 months. Well, yes, I understand your point. And as I said, this is a very controversial issue. Well, I'm not talking about other countries. You know, UK used 6 years. I think that I've repeated it many times, and you all understand that at this current stage, we're going to try to fight for legislation to be passed. Mr. Tang Ka-piu, and then Mr. Yu Si-wen. Thank you, Chair. Well, Mr. Tse has said that it should be more comprehensive, but I remember the first question I asked in the first meeting. Well, we're talking about a small number of people here, but there are a number of people who have completed full SRS and they hope to get married. So it goes back to a very realistic matter. If by amending legislature, these transsexuals could get married, then yes, I am in favor of doing something in accordance with the court's ruling. Secretary, don't be worried. You've already raised the draft, and now the responsibility is on our shoulders to see whether the legislation will be passed or not. Well, I can foresee some scenarios. First, what if the draft is brought up but it could not be endorsed by LegCo? Well, let's say the bill is vetoed by the LegCo. What could be done? Secondly, if by mid-July we're not able to deal with this by then we would have to wait till next year, and if someone or if another person comes up and say that he wants to get married, then what are we to do? Would already that be considered as another new case? Well, I think that the answer to these two questions would be the same. I must reiterate that we are going to do our best. Our constitutional responsibility is not only to bring the draft or the bill to the LegCo, we also need to ask the bill to be passed by LegCo. The government also has another responsibility to persuade the LegCo to support the government. This is something made very clear. We're going to do our best to persuade members to endorse the bill. This is something we must do. We could not go back and forth. We must be strong in our stance. In response to your question that if by July 16th the bill is vetoed by the LegCo, the court ruling will still come into effect. If a Hong Kong resident or a person is someone same as W who wants to get married, then we would do this in accordance with the court's ruling. After it comes into effect, then it will become part of the law of Hong Kong, and the government must work in accordance in respect of the law. And secondly, if there is still to be follow-up work carried out, the ruling would still come into effect. The same person would still have the right to register for marriage. The government would execute and implement the court's decision. So that person doesn't have to go through another case. No, because the court's decision is very clear. Yes, I understand, but that would, well, if in any event it would come into effect, then we would take a long time, to really to consider and discuss the situation. Yes, I've already said this earlier. We must to implement the court's decision in a timely manner. I'm sure that you've all read the draft bill. In the amendment, we need to amend some of the wordings so that it would be clearer in definition, and the person who is filling out the form to register for marriage would understand it very clearly. If we're not able to pass this on time, then we would not be able to amend the annex. Well, does it mean that it wouldn't affect marriage registration? Of course not. But I think this must be made very clear, because marriage registration is for someone who really wants to get married, for the general public. Not everyone might be clear with the definition. Therefore, we must write these down very clearly in the schedules. And it is because of these reasons that we are going to request for amendments made to the schedule in the definitions. Mr. Yu Si Wing, and then Ms. Sit Ho. Thank you, Chairman. Well, so the ball has been kicked over to the government side. So the court has handed down the order of the W case, and at the same time given us room to discuss this matter. But I think that if we put these two together in discussion, then we will never be able to come to a conclusion. I think that we should first go back to W and to focus mainly on the W case. A W case brings out the issue that we need to resolve the issue of those who have undergone SRS. For other people, they might be very complicated cases. For example, transsexuals or cross-gender people. But for those who have undergone SRS, it's very clear they've already been transformed to a male or a female. I think that the LegCo should go back to our constitutional responsibility and to first resolve the issue of the W case and to fight for the endorsement of the bill by mid-July. Well, if it is passed, then the government will need to make this clear, and if it is vetoed, then then so be it. But we should not delay this for much longer. Well, if it cannot be passed in July, are you going to continue with your persuasion or follow up on it work, or just stop it entirely? Secretary, as I said earlier, we're going to make our best effort to persuade legislative councillors and to tell the general public why we are doing this. We want this to the third reading of the bill to be passed by mid-July. So that is our objective. As for how the events would turn out, well, there are many possibilities. So at this point or at this stage, I can very clearly state that we only have one clear objective. That's it. Chairman, well, in future, we would all need to vote for it, and we must, of course, realize our responsibility to our electors. I think that the government should at least tell us know that if the bill is vetoed by the LegCo, what would be the role of the Secretary for Security, or Secretary, if your bill is vetoed, then what would you do? Well, I know that there will be comprehensive discussion later on, but we're not just talking about one problem here. We're talking about the comprehensive the IWG will try to resolve these issues to its best ability, to try to seek people's views. Well, this would be done in any event, whether the bill would be passed. The court order would come into effect in any case, and we would just do everything in accordance with the law. So, well, yes, if it is vetoed, then the Secretary for Justice would continue its work, and would if you continue with your work, well, let's say if it is not passed, would you bring this again to LegCo? Would that be one of your consideration, Secretary? Well, right now we do not have any other plans. Thank you. Ms. Head-Ho. Well, if you're saying that you want to persuade the government, well, you don't want to act like Mr. Chen Chi-chen and be very passionate. Well, let's talk about this calmly and peacefully. This is only, we're looking into the balance of power. Under the Constitution, I have to make clear that the court is not somewhere that you will need to make a head count. So, well, if you were talking about 9 judges, 5 against 4, why would you need 3 levels of court? Just do a head count, We don't need different courts, such as the Court of Final Appeal or Court of Appeal. Or even if the secretary wants to use different views to persuade LegCo, you must make clear the design of the balance of power and not to just try to make a head count. Well, we are talking about whether we should bring this to council meeting on July 9th. I agree that, yes, we could start scrutinizing the bill, but there should be more discussion. So I agree with Mr. Tan Chun's agreement to invite Dr. Chen and other experts. Well, I really want to express my gratitude to Dr. Yun for giving his expert opinion, but I agree that he's just looking at a male and female definition just by looking at the body anatomy. Well, yes, I understand that, but he only looked at male and female definition in accordance with body anatomy. And actually, for gender identity, there is also the gender identity disorder, and he said that this should be something under psychologists and psychiatrists. And as Mr. Chen said, you have not yet invited the members of psychiatrists and psychologists. And I said last time that there's also a suggestion by a association that they said that there's no need to go through the full SRS to be considered as a member of the other sex. If you look at CB2 if you look at the international experts' opinion, first of all, it says that yes, you don't need to go through the entire surgery to be confirmed as completing sex reassignment. And here there are many doctors on board. There are many medical doctors on board in the association, and of course there are also people from different backgrounds. Well, when there are different medical doctors from the international arena who hold different views with Dr. Yun, then we should not only listen solely to the views of Dr. Yun. So I suggest that we should invite other experts to come up here to give us their advice. And just now we talked about UK taking 6 years to come up with the gender recognition action, and now we also have 3 people following up with this. Well, since the UK also needs 6 years, I hope that the secretary understands that we don't want to complete this in 4 months. I agree that yes, you have brought up the bill to LegCo, but don't worry, you have already upholded your responsibility. We know that very clearly, and it's very rare that I'm in an agreement with other colleagues, like what Mr. Paul said. If you really respect the court's decision, you can ask the court to extend its decision. You could consider doing that instead of making us complete the scrutiny of the bill within 4 months. We see many different viewpoints from the public. There should be more discussion instead of just trying to rush through the bill. Secretary, any response? Yes, thank you. Well, I'm not sure whether I have the same view because our discussion has become broader. Many of the discussion is on gender recognition. The CFA in the W case is talking about a person who has completed full sex reassignment surgery. And can W be married in accordance with the current marriage ordinance? So I think that for this broader issue, it has already gone beyond the draft bill. I'm not saying that the government is going to look into matters outside of the W case, but in our current framework, we should focus on the order of the W case. Ms. Ho is right. We have 2 courts of appeal, and the final decision lies in CFA, and that is not an issue of headcount. But I want to say that in these 3 levels of courts, there are different views reflecting the complexity of this case. And because this is the final decision, the government has the responsibility to come up with a draft to amend the bill. And what we can do now is to persuade LegCo members to scrutinize the bill and to pass the 3rd reading as soon as possible. And we have no other plans at this current stage. Mr. Kwok, well, I see that there is a dilemma. On one hand, we have a decision of the CFA, and the CFA has affirmed the marriage right of W and people like W. And if we respect the court and the right of Ms. W, then we must use real or law or legislation to ensure the rights of W and people like her. But right now, where are you drawing the line?
If you draw the line here, there will be a lot of controversies. If you draw the line here, I don't need to repeat the Bar Association and Law Society's views. In the future, there will surely be judicial review. And as far as I know, there are already some groups of people who have not completed the SRS. Perhaps they have gone through 90% of them. They will definitely resort to JR. And this is inevitable. This is their right. And this is a problem arising from the ordinance. Justice Chen stated his views in the judgment. And when we consider the law, I think Justice Chan's remarks are influential, even though his judgment is not part of the principal judgment or ruling. He pointed out that this case will lead to a lot of arguments in society, especially about the concept of marriage. An IWG has been set up by the administration. You said that the IWG may need 2 years to do studies and to conduct consultation. In the coming years, after the IWG has completed its work, you may have to come back with new suggestions. Perhaps you want to scrap this the old ordinance, or you want to enact a gender recognition law as in the UK, or there may be other possibilities. So both sides are important in its way. So we have to find a way to balance all these considerations. Just now, Ms. Sid Ho pointed out that perhaps we can seek an extension from CFA. This is possible, but whether or not CFA is willing to grant that extension or for how long, yes, at the beginning they gave 1 year, and perhaps they now would be willing to give us half a year extension. Even with half a year, it may be difficult, as we can see from the public hearing, but we cannot say that, okay, we can just leave this bill. We don't need to pass it. No, we have to recognize the human rights of W. Even if we don't scrutinize this bill, the CFA ruling will take effect automatically. But then there is not an ordinance to confirm the human rights of W and people like W. This is not fair to them. So given this dilemma, I try to see whether there is a way to balance things out. Last time I suggested a sunset clause, and the Secretary said that that's not possible. That's not feasible. I hope the Secretary and other colleagues can consider whether this is a way out. The merits of a sunset clause is that, okay, if this is now passed, the sunset clause will state clearly that the administration will have to do consultation and studies. After 2 to 3 years, you have to come back to report to LegCo. That after the extensive consultation and studies, what is the outcome and what is your next step? If you think that there are a lot of reactions in society and all the deputation's worries have been realized, you have to come back to us. But if you think that, okay, after this bill is passed, you don't need to come back, then this ordinance will lose effect. Now, the responsibility rests with you to deal with this very controversial issue in the coming few years by means of consultation. This is my preliminary suggestion. I'm not saying that I will surely move CSA. I just want to find a way out. And I hope this, the administration and colleagues can consider whether this is a solution. A brief response, please, Secretary. I said last time that if there is a so-called sunset clause, then after the sunset clause, let's assume that this bill can be passed. Okay, then this ordinance will lose effect at that time. At that time, it's just like that when this bill is not passed. And the member said that the government will be given the responsibility to work. But the administration has said clearly that the IWG under the Secretary for Justice is already working. Even if this bill is passed, we won't say that tomorrow the IWG will stop working. This is not something we will do. We will take up our responsibility to deal with this matter, even though it is a very complicated issue. We will surely handle it. Thank you, Chairman. Mr. Kok Wai Kang and then Mr. Leung Ka Lau. Thank you, Chairman. Since the past meetings till now, the Secretary's words and tone is very clear. Now the CFA has made its ruling, and it is expected that we can complete scrutiny of this bill before June this year. I hope colleagues will be clear about this. It seems that everybody wants to add a lot of things and take out a lot of things, so that we will need a lot more time to discuss. But I hope that we can concentrate on the contents of this amendment bill. Why? The paper is very clear. No matter whether this bill is passed, the CFA ruling will take effect. It will apply to the whole Hong Kong. If we can complete the scrutiny of this bill, then at least I think the legislature and the judiciary show respect to one another. We are collaborating. We don't want to give others the impression that there is always conflict. We are always in objection to one another. Apart from the Secretary, many other groups and organizations have come to try to persuade us. There may be a big gap in the ordinance, and in the future there will be a lot of problems. I understand their worries, but I hope that you will understand that the CFA ruling is not reversible. We have to face up to that. LegCo has to respect the judiciary, or the executive needs to respect judiciary, and so they want us to complete our scrutiny work. But we also hope the administration can respect us, because colleagues have said that we need more time to do our work. So how much extension can we get? Just now, some members asked this question. I won't ask this question. We said many times that we hope to get more time to do our work. After so many meetings, has the administration applied for an extension? If so, then when will there be a reply? If not, the administration wants to show that they are determined. They want to fight till the last minute. But I don't think you want to tell others that you haven't completed the work on the day after the 17th of July. So when will you apply, and when will you get a reply? Yes, will they do it? Secretary, we will try our best to strive for the earliest passage of this bill. Today, we still haven't applied to the court for an extension, and at this stage, we do not have this plan yet. Mr. Leung Ka-Lau, my questions are very simple. Under the law, how is male and female defined? Secretary, how is male and female defined in the law? There is not a definition in the statutes about male and female. No. But in the court ruling, there is detailed account. Can you elaborate more? My answer is so short, I think you should give a lengthy answer. Chairman, as the Secretary said, there is not a definition of male and female in the statute, but the CFA ruling explains the concept of male and female in the marriage ordinance, and that's the gender at birth, and that's in accordance with the UK. But then the CFA is of the view that if that's the interpretation, we cannot comply with the human rights ordinance and also basic law. Now, if SRS is performed, then the person, the transsexual, can get married to a person of the other gender. Mr. Leung, if there is not a basic definition, then now in para 7 of the paper, you said that through statutes, it is clearly defined that one male and female can get married based on the definition of male and female. Then this is not true, because after the amendment, there will be this scenario that after SRS is performed, then there is a male or female. But for people who haven't gone through the operation, then how will their gender be defined? There is gender at birth. Of course, I am a doctor. I've seen a lot of very eccentric cases or odd cases. After a few years, let's say the doctor may change his mind about his decision of the gender of a child. So in this amendment, you cannot really clearly define a male or a female. Dr. Leung, so your view is, now from a medical point of view, you cannot really differentiate who is male or female? No, in most cases we can differentiate. So there is still a definition of male and female in the medical field, right? There are different dimensions. Now, in the public hearing, people said XX chromosomes is female, XY is male. Then what about X0, XXY, and XYY? What are those? For most people, they are either XX or XY. But very, very few people may show mixed results, even if the chromosomes are XX or XY. Now, in the development of the embryo or fetus, with the hormonal effect, the sex organs may be such that they are skewed towards the other gender. So I am asking for a legal definition, or I'm not asking for a medical definition. In medical science, there may be different definitions, but that is a big problem. So I'm asking for a legal definition. Now, this is different from Ms. W's case. And in CFA's ruling, in the marriage ordinance, and also in the matrimonial causes ordinance, according to the UK law, gender is defined according to the gender at birth. So if we do not add in these two clauses, we cannot clearly show that how a person's gender can be defined if SRS has been performed. Okay. After the full SRS is performed, you can define whether that person is a male or female. But in other cases, there's no way you can define, right? Because right from the beginning, there's not a definition. You just go according to the gender stated in the birth certificate, and there's no other means of definition, right? Principal Deputy Secretary. Yes, we will go according to the gender at birth. And what Mr. Lau just described is not contained in this case and in this bill. Okay. Any other members for the first round? No? Then there are 3 members in the second round: Lang Mei-fan, Chen Shih-chun, and Paul Tse. Any other members? Sid Ho, Kwok Wai-keung. Any other? In order for members to be able to make their points, I will limit the time to 3 minutes each. Lang Mei-fan. Yes, Chairman. I cannot agree to Mr. Kwok Win-hung's amendment. I can't agree to that direction and content. We're talking about a marriage system. If we say that the 1st of August 2017 will be a deadline, then that will be a nightmare. Then it seems that even the marriage system is very fluid. We're not talking about a situation like the order about formula milk. Now, we are talking about 2017, and all these studies and consultations have to be done. I definitely cannot agree 100%. Many colleagues said that the court's ruling is very clear. They will insist on 1 male, 1 female. They won't say half male, half female. Some people's gender is not stable. But in our debate last year, we already talked about that. At that time, many colleagues disagreed. 148 and 146 paragraphs.
Should be enacted. 148段呢就係如果呢樣嘢做唔到啦，嗰個 such
If these are not possible, such declaration will in principle come into effect in any event at the expiry of that period. At that stage, consequential legislation may or may not be in place. But W's entitlement to appropriate relief should not be affected. So that's about W's case. But now we are digressing to the UK situation. I don't agree with Paul Tse. The court suggested that we can discuss, but the court is smart. They know that there is not much consensus in society. So Paris 2 states that this is not related to homosexual marriage. Now, the three arms should respect one another. So they should leave serious controversies to LegCo to handle. Kwok Wing-hung said after 1st of August 2017 that must be done. This is not possible. Different members reflect different views in society. Can we build a consensus in 3 years? Do we need to amend the marriage ordinance? Perhaps this won't be handled via the marriage ordinance. So I think this is not operable. And this is not temporary in nature. We are not saying the administration does not respect LegCo. I think the court should also respect LegCo. There is not a mandate from government. This is highly controversial. LegCo hasn't given you a mandate. The court did not compel you to follow UK. Okay. Members, can you please use one language, either Cantonese or English? Otherwise, our interpreters' job will be very difficult. Chan Chi-chun and Chair Wai-chun. Chairman, I want to point out this point. The Secretary said that they have just reflected the CFA's ruling as it is in the bill. I think this is a deception because Bar Association and Law Society said that only those who have the full SRS performed can get the right of marriage. And CFA doesn't have the intention to say that only those who have gone through full SRS are eligible to get married. I think the Secretary has interpreted the CFA's ruling. If that's your belief, you have misunderstood them. If this is done deliberately, then you are deceiving people. EOC has made a point. In the bill, the administration can say that the relevant people can follow the administrative instructions to apply for change of gender on the Hong Kong ID, then that relevant person can get married. The administration has not discussed with us about this, so I want to know the administration's position. If you think this is not feasible, why?
Secretary, all along, we've been working in accordance with the opinion by the HA. The court's ruling can be, to a certain degree, listened to this opinion because the court has quoted from the opinion given by the doctors from HA. And the court said that for people like W, people can get married in that reassigned gender after going through full SRS. Well, the court has discussed other issues, but the court has stated right at the beginning that this is not about same-sex marriage, and the case is for people who have gone through full SRS, whether they could get married in their new reassigned sex, and the court's judgment is very clear. I do not believe that the bill today, I must reiterate that it is in violation of the order handed down by the SFA. Chairman, I never said that. I never asked about a same-sex marriage. I just want to ask what he thinks of Dr. York's child opinion. Well, Mr. Paul said, well, Ms. Leung said she's not in agreement with she must have not listened very clearly. I just said that that the 12 months period is a bit too long because we're not talking about W. If we're just talking about W, then we don't need the 12-month period. The 12-month period is for us at LegCo to do something for people other than W. And I don't agree with what Ms. Sit Ho said. She said that, well, it's not a problem of headcount. Well, of course, when we talk about the current legal situation, of course, we would look at the headcount, like in LegCo. But then very often we're only talking about concepts and principles. So I think that goes beyond a basic headcount. So I believe that, well, that there is a 5-4 in the judge's ruling, and that it's very controversial. Well, of course, we in this field will not only look at this of this ratio. We would also look at the content to see what they said and in what are the other opinions that they have expressed, and whether there are any other opinions from different jurisdictions. Because, of course, I understand that we are not just looking at the headcount, we also need to look into the contents. I'm going to use up all the time because I'm not seeking for a response from the administration. We're not just talking about vacuum here. Because it's not that we're not able to do anything by not passing the bill. W and people like W case have already been made very clearly, and that has already resolved certain issues. Dr. Leung Dr. Leung just now said that we're not just talking about basic rights of those who have gone through sex reassignment surgery. Secretary said that they're going to do everything in accordance with the order as it is, but you're not doing it as it is because the CFA has said that you have 12 months to complete everything else, but it doesn't mean that you have already done everything clearly. So you know, nobody is winning here. This is not a good situation. I don't think that we'll need to try to escalate the conflicts right now. I believe that if you think that LegCo can help you, we would veto the bill. But if you think that you should do this more responsibly, I think that on one hand you need to seek extension from the Court of Final Appeal, and at the same time you need to try to speed up the other progress at LegCo. Thank you, Ms. Ho. Yes, Chair, I would also want to follow up on, well, I think that we should to seek other expert opinions to tell us more about the gender recognition issue. So, Chairman, would you please arrange for meeting with psychologists or maybe with those who have the knowledge on gender identity, such as Dr. Yun, so that we could seek their advice. Well, aside from seeking the advice of Dr. Yun Wai Chang, have you also seek advice from other experts? Because like Dr. Leung, he's also a doctor. He also thinks that there is a problem with the definition. So he asked a very simple question on whether there is a definition of male and female under the law. So this seems very obvious, and there may not be a definition under the law. But now we are dealing with such a controversial definition. Dr. Leung Ka Liu's question is not unnecessary, because if we're just looking at the issue we're talking about, we do need to know about the definition of male and female. And I think that we do need more medical advice, because right now we're not dealing with the deadline of July 16th. Because, as we said earlier, you could seek for an extension from the CFA. Secretary. Well, I understand Ms. Sit's whole main point is going back to gender recognition. The CFA, in my understanding, on the case of W, is not targeting the issue of gender recognition. And the court does not think it wrong to accept a person's gender of its gender from birth. I don't think there is any question on that. In human society, everybody knows very clearly we are just now targeting special exceptions. No, I don't think that requesting a further understanding or discussion on gender identity would be helpful. Well, of course, this is something we need to deal with later on, and precisely so, we are going to do this in the future, and the IWG will seek consultation, and there is plenty of time for everyone to discuss and express their views and to listen to the views of the experts. Chairman, well, this is like a part of the difference between LegCo and the administration. We want to make this clear now and not to think that we have plenty of time to discuss this in the future, because we need to know or understand it clearly before we could make a vote. It is your responsibility to say what you did, but we also have the responsibility to understand clearly the issue so that we could explain it to the public. Of course, we play different roles. I think the Bills Committee should arrange for other medical experts, such as Dr. Yun Wai Chung and others like him, to share with us their views. Well, we've discussed this matter for almost 2 hours, and we've already stated many key issues. On July 16th, people like W would be able to get married under the marriage ordinance in any event. There would not be any impact on them. But of course, we also need to look at the different viewpoints of members. Right at this stage, we still don't know how the bill would be seen, or how the vote would be. Well, there have been over 100 members of the public here last time to express their views, and they have made many written submissions. I think this gives rise not only to the bill, it also gives rise to issues such as gender identity and other related issues. I think if we are to continue with our discussion, we're still going to focus on the same issues. I think many of the issues are already a repetition of ideas expressed before. I think we need to be realistic. I think we need to make some decisions. First, well, if the Secretary Bureau has already stated its view, should we deal with this before July 16th? Well, it really depends on your decisions. Secondly, regarding the scrutiny of the bill, I understand Mr. Chen Chi-chun's request to seek more experts' opinion do you think that there is a need? I think that members hold different viewpoints, something that it's enough. Some believe that we should invite more views. So I think that, well, up till now, I believe that, well, I don't think we need to focus on the other issues right now, but we just need to understand how to go forward. Well, there are some amendments proposed. Well, we would need to do that when we scrutinize the bill. Well, everyone has already expressed their views. Well, I should seek your advice. We don't have a quorum to make a decision today, but I just want to raise these issues in how you can express your opinions, and I would seriously consider all your views. And Mr. Chen Chi-chen, I would give you some time to talk about your point later. I think at this point we need to come to a decision on how to go forward. Well, the bill is in your hands. Are we going to pass this? If we not talk about gender identity or transgender, I think we would maybe discuss this later on, because right now the focus is on this bill. Mr. Chen Chi-chen, well, I don't want to discuss, Chair, how you're going to draw a line on how long the future discussion would be, because this could be there could be no boundaries to that. Last time, Dr. Yuen Wei-chung said that he's just the medical expert on the final part of the surgery. He said that he's not an expert in psychology. And today I've heard many members quoting from Dr. Yuen, and that would affect their voting in the future. So I think that in regards to completeness, we should at least talk to a psychiatrist and psychologist, because they actually spend more time with these people, because Dr. Yuen is only in charge of the final part, which is the surgery. So I think that there should be an opportunity for us to meet such psychologists and psychiatrists and to seek their views. So in my letter, I say that Mr. Mark Kai Lok from Castle Peak Hospital, he reaches out to many of these transsexuals, and also Dr. Man Lun from the Hong Kong University, and these doctors could actually help us because Dr. Ng has a lot of experience in this field. Well, we don't have much time. We need to finish by 12:45. We have how about 2 minutes each? Ms. Lau Mei Fan. Well, I don't need 2 minutes. Well, either don't invite them. If we invite them, then we must seek advice from different fields. I suggest Paul Diamond, because I think if you want to invite, then you must invite Paul Diamond as well, because he has practical experience in this field. And everybody was talking about that earlier. So I just, either you don't invite anyone, otherwise you should invite people of different views. Mr. Fan, Well, I agree, or I'm in favor of Mr. Chan's request in inviting psychiatrists and psychologists to attend our meeting, because I think that would give a more comprehensive view of these issues, because this is not something solely limited to surgeons. We must listen to different views, and that would better help us in our decision making. All right. I would use my discretion to extend the meeting by 15 minutes. I think that if you have such views, I would invite related psychiatrists or psychologists to attend. I'm not sure whether they would be able to attend, or maybe we welcome suggestions or recommendations given by the administration as well. We would invite them on behalf of LegCo. The administration could also assist us in giving recommendations. We need to consider whether we should come to a decision by July 16th. This is something I need to consider. The administration has already said that they're not going to seek an extension from the CFA. If that's the case, I want to hear your views before I make a decision. Well, many of you have raised your hands. Please keep your hands up. Ms. Heto, Mr. Yu, Ms. Leung, Mr. Leung, Kwok Kong. Okay, let's focus on this one point. 2 minutes. Ms. Heto. Chair, I don't mind you bringing this to the Council on July 16th, but I think that before we start the second reading, we need to arrange for the psychiatrists and psychologists to give their views.
As we all know, this is a very controversial issue, and from now till the 9th of July, I don't think there will be a consensus. We can then take a vote, but we still have the responsibility to find experts from various sectors to help society to have better understanding. Paul Tse, I have to repeat that the 9th of July line is not realistic. I think that line is not for us to legislate on the W case. It's about people other than W. So we do not need to be too serious with this line. If we cannot complete our work, then I think there's the CFA ruling for the WA case. If we want to follow what CFA said, we have to work on other things apart from the W case ASAP. So I think the Secretary would be happy to see that at that time, well, at least you can have passed on the burden to others. I am not against listening to more views. If we have to rush for the 9th of July, I think that is a misconception. We have to make sure our direction is right. I think members have expressed their views clearly. Paul Tse doesn't agree. You're saying you will disregard the 16th of July deadline. That's not the only point. I don't think we need to rush to meet this 16th of July deadline. That's another thing. Yu Si-yun, Chairman, I agree that we can listen to doctors' views. We can invite them to come. Now, if we invite some doctors to come, but then if they are not related, if they give very mixed views, then that would be a problem. So we want to listen to clearer views. I agree that this bill should be tabled before the 9th of July. The purpose of setting up this committee is to handle this case. If this is to continue indefinitely, then when can this committee be dissolved? Leung Mei-fen, Chairman, I think more time should be allowed for experts to present their views. I think Justice Yun's working group should consider this. I think it's easy to have Hong Kong experts to come, but for Paul Diamond, of course, we will provide information. He said that he is more than happy to come to give his views. Perhaps a video conference can be arranged. Now, we take time to listen. We take time to learn, but he has real-life experience, and he said this is a very painful experience. We want to have different views. We cannot only listen to experts in Hong Kong. Chairman, I think you can refer to the timetable. Let's see whether all these should be done now, or this work should be taken up by Justice Yun's working group. Mr. Leung Kwok Hong. Now, there is no deadline really in the world, unlike the interception of calls issue. If we want to invite deputations, it is better to be more comprehensive. The court asked us to look at the UK practice, but at least you should let us know what the UK is doing. Otherwise, things are not meaningful. So I don't see really that there is a deadline. The court is not going to beat us up. Unless if the court's ruling is not enforced, then there may be JR. Then there may be civil compensation. So we don't need to be too scared. If we enact bad law, that is very bad. We can't be too hasty. Secretary, if anyone is going to challenge you, I will support you. I will protest to the court. If the court makes a decision or judgment that is not feasible, and judges are not superior. Now, in my JR case, interception of call was not feasible, and you don't need to worry. This case is different. Okay, I hope that in your remarks you have to pay attention to public opinion. Please make sure that we are showing due respect to the judge. Emily Lau. Okay, members agree that we should invite experts to come. Okay, I support this. There is no difference in view here. Chen Chi-chun. I am against rushing for the 9th of July. This is going to be a bad precedent. Next time, if CFA draws a line, and then if the administration tables the bill 2 months in advance, then are we then again forced to complete our work in 2 months? It's up to LegCo to decide how long we want to scrutinize the bill. The stamp duty law took 1 year. We do not intend to procrastinate. We ask normal questions, but then the administration cannot give satisfactory answers. We have checked with the legal advisor that the administration's papers and responses are not clear, so there should be enough time. We don't need to pay attention to the administration's or the CFA's timetable. Okay, members have expressed their views. There may be different views as to whether the government has given adequate answers. They are of the view that they have answered our questions. It's up to us to decide whether the answers are acceptable. And of course, we won't just stop our scrutiny. We don't agree that this scrutiny work should be indefinitely long. But what we have to do is to make sure that remarks are well expressed. The same applies to all bills. Today I won't make a decision. I will write to all members about timing to see whether members agree that we should try to complete our work before the 16th of July. Now, if that is agreed, then I will add more meetings. I will make sure that there will be time for adequate discussion. Just now you said that other professionals should be invited to come. We have already made a decision, so I will go according to that decision. If you say that we can disregard the 16th of July, well, colleagues have different views. Some want to respect the courts. Some may have different views. So I will allow you to make a decision. That's the arrangement I will make. With the majority view, then I will make a decision about the timing. So it only affects the frequency of meetings. So I believe we have to adjourn here. Our next meeting will take place on the 5th of June, Thursday at 8:30 a.m. Thank you for attending this meeting. The meeting is adjourned here. Thank you.